In this podcast, you're the client, and you're coming in and you're asking me the question that we get quite typically. I've got this $500,000 IRA. Who should I name as the beneficiary of that IRA? And that's a topic. If you ask 10 different advisors of financial planners and CPAs and attorneys, you'd probably get 4 or 5 different answers, because there is not a right, correct answer. A lot of it depends on what you want to accomplish from a tax standpoint. But I think even more than from a tax standpoint, I always start with this. When I'm analyzing who a client should name as the beneficiary, to me the very first question is, from a financial standpoint, who really needs that IRA? Who needs to live off that IRA? Does my spouse need it? If my spouse needs it, there's an easy answer. I'm going to name my wife straight up as the beneficiary of that IRA. If my wife doesn't need that, and I have a pile of other assets that my wife can live off of, from an income tax standpoint, my next best choice is to name my children as beneficiaries of that IRA. And I'll talk about that a little bit more in a minute when I talk about the minimum distribution rules. But even better than that, if my kids don't need the IRA, from a tax standpoint and a deferral standpoint, my grandkids are a phenomenal choice for the beneficiary. Now I'm going to lay out kind of our options up front, and then I'm going to come back and talk in greater detail about the minimum distribution rules and how they impact this decision. But start with this other proposition. My other options from naming my wife or my kids or my grandkids would be, what if I created a trust for the benefit of my wife? Or what if I created a trust for the benefit of my children? Or what if I created a charitable remainder trust to be the beneficiary of the IRA? So this question, who should be the beneficiary, is not as simple as it sounds on its surface, because I have probably 7 or 8 pretty good choices. Now let's go back to my wife first. As I mentioned, that's a great choice if my wife needs that money and she needs to live on it. If I name her directly, we know from my other podcast, she can do a spousal rollover. I die, she can roll the IRA over into her own name. She could defer the minimum distributions until she's 70 and a half. She could name her own beneficiaries, and she just steps into my shoes. The problem is, what if instead of my wife Nancy, who I've been married to for 41 years, what if Nancy had already died and I've got a new wife, and I won't mention her name here on this podcast because I don't want to sound like I have her picked out yet. But what if I had this new wife? Let's just we'll call her Betty. That's a good safe name. What if I don't want to name anybody that Nancy knows, that'd be dangerous. But what if this new wife is Betty, and I've only been married to her for a year? Now, you know what? If I name her straight up as the beneficiary of my IRA and I die, Betty rolls that over. It's her own IRA, and she names her own beneficiaries. And Betty has her own kids that are different than my kids. Betty's probably going to name her children as the beneficiary. My kids are going to get disinherited. So I would be better off, if Betty's my wife, that I create a trust for the benefit of Betty. I name the IRA to the trust for the benefit of Betty. Betty gets to live off the IRA as long as she's alive, but when Betty dies, inside of the trust, I've named the beneficiaries as my children. Now the nice thing about doing this is now I have control over the IRA beyond my death. Betty gets the economic benefit but doesn't have the control. Now, if I'm going to name a trust for the benefit of Betty, I've got to make dang sure that trust is what we call an IRA look-through trust. Now, here's the situation. Generally speaking, the IRS does not like a trust as the beneficiary of an IRA. So generally speaking, when you go back and ask financial planners, attorneys, and CPAs, generally they'll say, do not name your trust as the beneficiary of the IRA. The reason they say that is a trust does not have a life expectancy. A trust does not have a heartbeat. A trust does not qualify for minimum distribution rules to be stretched over the lifetime of the beneficiary. And when it comes to IRA planning, the name of the game is stretching the income tax consequence over the lifetime of the beneficiary. The smart thing to do is, if my wife's the beneficiary, she takes distributions over her life expectancy, defers that income tax. Generally speaking, IRS says a trust cannot qualify for that stretch, and if you name a trust as the beneficiary for Betty, you have to pay the income tax over a 5-year period. Now, the exception is if you make that trust what they call an IRA look-through trust. Good estate planning lawyers can draft language in that trust where it can be controlled for the reasons I talked about for Betty, but I can still look through the trust to Betty's life expectancy, and I can have those minimum distribution rules cover her life expectancy. Now, what about the children? We also talked about that I can name the children straight up as the beneficiary, and we learned that that's an inherited IRA, and we learned that they have to start distributions in 1 year, and we learned that distributions would be based upon their life expectancy. Well, the problem naming the children straight up, what if my child's 8 years old and not 38 years old? You can't name a minor beneficiary. Or what if my child had special needs and is on government assistance, and any benefit from an IRA would disqualify government assistance? Or what if I thought my child is a spendthrift, and even though the smart thing to do would be to stretch it out over life expectancy, my child cashes it in early and pays the tax? So I'm making the argument that for my child, I should create a trust. Now, back to my situation where my daughter's named Rochelle, she's 38 years old. Instead of naming Rochelle directly as the beneficiary of the IRA, I name a trust for the benefit of Rochelle as the beneficiary of the IRA. I die, we make that trust a look-through trust like I talked about earlier. The trust becomes the beneficiary. We look through the trust to Rochelle's life expectancy. The minimum distribution rules are tied to her life expectancy. Now, by naming that trust, I've accomplished two things. Number one, I've stopped Rochelle from making the foolish decision of cashing in early and paying all the tax up front. I have an independent trustee that would not allow her to cash in. She takes the distributions and she lives on the distributions. That's the first protection. And as I mentioned in my prior podcast, as much as clients like to stretch out IRAs, stretch out the income tax, and get this deferral, statistics show that on inherited IRAs with respect to kids, they do tend to cash them in completely within 1.5 years of my death. It's found money. They pay the income tax because they want a boat or a car or a new house. A horrible thing. I want the look-through trust to protect that. Now, the last thing, just quickly on charitable remainder trust, there's some phenomenal income tax benefits and charitable deduction benefits where I can name that charitable trust as a beneficiary. But I hope that answered most people's questions. Who you should name as beneficiary of your IRA. Start with the first question, who needs it economically? Second question is, once you decide who needs it economically, decide whether you want to protect the IRA against that beneficiary from doing something foolish, and decide whether you want to get that IRA credit or protected. And in my situation, I highly recommend what they call an IRA look-through trust. So in my situation, I named my wife Nancy straight up as the beneficiary of the IRA, and then I've named IRA look-through trust for the benefit of my kids in case Nancy predeceases me. But I hope that helps, and the main thing is give this thought and give it consideration. Is not an easy question as it seems to be on its surface.